employment law update. I have delivered this in Skipton on the face-to-face events, which take place at HML. Just a little bit about me, for those of you who don't know. We've got quite a few attendees today. We're a niche employment and family law practice. We've got 8 people working for us now, set up in 2014. I'm 15 years qualified, and I also do a bit of visiting lecturing as well. I present regularly, obviously on the webinars, and Skipton's my patch. So if you're ever in the area and you want to pop in on any of the particular North Yorkshire events, come and say hello. Okay, we're looking at, it's a summary today. What I've done is I've kept the slides the same, but the actual event lasted about an hour and a half. So I'm going to skip over some slides, and you will get the slides afterwards in the usual way. If you do have any questions, I'll try and come to them at the end, or if I can, I'll pop them in if I notice them as I'm talking. And as Karen said, if there's anything particular, do email me directly or contact me after the webinar. Okay, so it's just a bit of a reminder really since the last update, which I think was in April 2016. Right, so I'd like to start with 0 hours contracts then. Just a refresher here that exclusivity clauses in these contracts was rendered unenforceable in 2015. Okay. The relevant act was the Small Business Enterprise and Employment Act. It inserted a new section 27A, bracket 3, into the Employment Rights Act 1996. There are now remedies for unfair dismissal and any detriment that might be imposed on workers who fail to comply with an exclusivity clause. There's been a lot about this in the press. If you use 0 hours contracts and you need to review them, it's just a reminder, partly because I've come across a few recently in dealing with some of my clients, and we've just tweaked them a little bit. They were old precedents that seem to be, how can I put it, no longer fit for purpose. I think that's probably the best way to put it. Okay. By way of further update where we are with employment tribunal fees, we've still got this unison challenge going on. They've had leave to appeal to the Supreme Court. In general statistic terms, claims are down. Successful claims are also on the decrease, if you believe the stats. And the government's post-implementation review of the fee regime is still ongoing. So we expected initially a review, a proper review document or feedback in 2015, and it seems to be being put back and put back and put back. Now, in that regard, a more probably relevant to you guys might be that use of ACAS early conciliation is on the up. I don't know whether you've had any experience of, in fact, somebody's just said, is ACAS early conciliation up? Yes, it is. So early conciliation is on the up. I don't know about your experiences about whether it's working or not. I've had varying feedback from people on the ground. Some of them are saying that it is working. Some employers are saying to me that they are experiencing a lot of contact from ACAS, but they're not receiving the claims, and they're not settling claims at ACAS early conciliation stage. Again, I think there needs to be a full overview of what is and isn't working now. And certainly my experience at the moment, in the past sort of 6 to 8 months, is that the claims that are progressing on behalf of claimants, claims where the claimant is insured and might be covered under home or content insurance policy. They are often covered under legal expenses cover, up to £50,000 on some of these policies. So those are the claims I'm seeing proceeded. I'm sorry if the sound's not up to scratch. I do have all the speakers on full, so we'll just have to take it from there. Sorry. Okay, I say breaking news next then. So another thing that might be of interest to you, it's not really breaking news, I'm being a bit sarcastic, is a report from the Women's Inequality Committee. They're calling for better pregnancy and maternity protection, and I've put this into the update because it is linked with the fees issue. Basically, what the committee have discovered, and based on some research, is that 77% of women reported negative experiences at work relating to pregnancy or maternity, and that they were not inclined to pursue matters or not in a position to be able to pursue matters to an employment tribunal in relation to any discrimination suffered. And that's partly because, or one of the issues that's been raised is whether that's partly because of the fee regime, because if an employee has been away on maternity leave and hasn't had any enhancements, then she doesn't have the relevant funds to be able to lodge claims. And also in relation to timescales. So, for example, just by way of refresher generally, remember for discrimination claims, it's 3 months from the date of the act of discrimination to be able to claim. Now, in relation to pregnancy and maternity discrimination, there has been a suggestion that it might be fairer to introduce a 6-month time limit in this regard. So these are all things that are being discussed, as is a potential decrease in the fees payable if it's a sex discrimination claim relating to pregnancy or maternity. So instead of the £250 lodge fee and the £950 hearing fee, that could be significantly reduced. So I say breaking news. I don't know what will happen there. Maybe nothing will happen, but certainly it's on the agenda. Next, then, the Employment Tribunals Act. Just a refresher on this, there's a new part of the Employment Tribunals Act to allow financial penalties now to be imposed on employers who do not pay out any employment tribunal awards or sums due under a COT 3. And that came in from the 6th of April this year. So depends when you had your last update, but I'm sure that was mentioned. The relevant act there is the Small Business Enterprise and Employment Act. So we can now, there is now a financial penalty if awards are not settled. And there is a scheme for enforcing awards as well, and a methodology of doing that. So in other words, I think it's fair to say that if you do become subject to an award or you enter into an agreement, please do pay the money. It's becoming easier to enforce. Moving on from there then, another relevant issue this year, there was a webinar earlier on about this, was the gender pay gap reporting. We expected to have the final regs out by now, but we haven't. So where are we with that then, by way of the update? The final regulations are expected to come into force by April 2017. They apply to large private and voluntary sector employers. I think there's a consultation at the moment about public sector as well. And when we say large, we mean 250 or more employees. I mention employees there briefly. So if you are in a company that might be affected by this, you might want to at the moment be looking at whether you actually fall within the definition of those who are affected. So for example, do you actually have 250 employees or more? What's the nature and the working status of people in your businesses? Start doing a breakdown now. Have a look, see if you can, get one step ahead of the game there. I mean, basically, what will this mean then if you are affected? Well, the regulations require employers to publish the overall gender pay gap figures at the mean and median average, and also to publish details in quartiles, so four pay bands based on the employer's overall pay range. It also requires publication of bonus gaps. So, and bonuses are also included in the definition of pay at the moment, or the last regulations, draft regulations that I saw included them. So it's also going to be required that the businesses publish these, probably on a website, publish them within 12 months, keep them online for a longer period of time than that, and notify them, and put them in a place where they're easily seeable. Now, in relation to the gender pay gap regs that we saw in draft, the main question I've been asked regularly is, well, what's the penalty if we don't comply? And at the moment, as far as I could see, there is no financial penalty. There was talk of a financial penalty, but at the moment, it seems to be lacking in teeth. Whether that will be changed on the final regs or not, I don't know. The gist of the gender pay gap reporting is that people or companies will be embarrassed and they won't be able to attract or retain staff if they've got huge pay gaps there. So, as I say, assess various things at the moment. There are steps you can be taking, such as looking at what types of workers your workforce is made up of, taking some particular advice in that regard, and then doing quick recce's on your payroll already, and seeing if there are any issues up front that you can resolve. Some of them might be historic, it might not necessarily be intentional. So that's where we are with that, and there'll be probably more to say about that in the next April update. Well, I hope there will anyway. Just on that case, in relation to pay gaps and equal pay, I just thought it might be interesting there to highlight the ongoing Asda case here. There is an ongoing equal pay case being brought by employees of Asda at the moment. They've just been given permission, I think last week, to proceed with it by Manchester Employment Tribunal. At the moment, the information I've got is that equal pay being brought by 414 employees of Asda. And in this case, the claimants are mainly women, and they're saying that their staff jobs in the store are of equal value to higher paid positions in Asda's distribution centres. And what they're saying is that these positions in the distribution centres are mainly held by men. So we're looking at equal value claims, and that's an ongoing issue. There was a preliminary issue about whether they could bring the claim last week in Manchester based on whether it was the same establishment, and a number of other things. Have a good look at the case if you're really interested. I haven't got time to go into it now, but it is proceeding, so it's a watch this space job. Okay, and the next thing to look out for in this next year or so, hopefully, is we're looking at grandparental leave. Now, this has been something that people have asked me about quite regularly, actually, and it's planned by the government to extend shared parental leave to working grandparents by 2018. Again, I don't know what the take-up has been in your businesses of shared parental leave. Certainly, the feedback from a Personnel Today webinar that I did the other week was that the number of requests is high, but the number of people actually exercising their right to take the leave is not reflected at that level. So, interestingly, I've had a number of smaller employers who have been affected by the shared parental leave requests and have had employees taking the leave. And some of the larger organisations who were expected to have a large number of requests, they haven't felt that. So I'd be interested to know your feedback on that later. Now, in relation to whether to progress this to extend it to working grandparents, I don't know if this is a good or a bad idea. When I'm speaking to employers and companies on the ground, what they're saying to me already is that it's not necessary because a lot of grandparents are already requesting flexible working since the changes. So since the requirements changed for flexible working requests, we've had lots of working grandparents making flexible working requests, dropping a couple of days to help out with childcare. And that seems to be working quite well. Again, it might be something that you've experienced or not, but it might be something you can use in your organisation. There's also a suggestion that instead of extending the shared parental leave, which is about obviously after the birth, whether parental leave generally could be extended. So just by way of a recap on that, in addition to the various kind of leaves, we've got parental leave, which gives every employee for children under 18 the right to take 18 weeks unpaid leave up to them being 18, basically up to the children being 18. And so in my experience, we have people who take blocks of leave for long school holidays. There's lots of other reasons it's taken, but it's basically to plan for care for the children when it's not an emergency. That's time off for dependents. Now, whether that could be extended to grandparents or not, I don't know, but that has been one of the other suggestions Of course, that's unpaid, so I don't know how that would go down, but then again, if grandparents are making flexible working requests and dropping days anyway, it might be that that's the way forward. We have discussed in North Yorkshire, so if anybody, I'm presuming everybody who's on is from the North Yorkshire, but it might be from further afield than that, we are looking at doing some ageing workforce issues sessions, whether that's politically correct or not, but we're looking at implications of ageing workforces and things going forward in a face-to-face session shortly, so in the next 12 months. It's definitely on the agenda. It's been requested by some of the members. In relation to just before I move on then, I have had a question about do I know what was driving the low take-up after the initial request for the shared parental leave. I don't know definitively, but certainly on the feedback that I have had, I believe that the low take-up has been either because of the complexity of it for the individuals who just can't be bothered, or because in the end it wasn't working for them, or they thought they'd be better off than they were. So no, I've had lots of general feedback on that, but I don't know if there's an overwhelming reason. Let's have a look. Now, holiday pay. So we've had this recent, it's very recent. So, sorry, I just turned my file over there. We've had a very recent bit of feedback on this holiday pay of case on Lock and British Gas. Okay. In a nutshell, the Court of Appeal has upheld the Employment Appeals Tribunal's decision that the working time regulations should be interpreted in accordance with the requirements of EU law to include a representative element of results-based commission in the 4 weeks of statutory holiday pay, and that's under Article 7 of the Working Time Directive. So there's been this question ongoing, and you'll obviously be aware, unless you've had your head in the sand for the last 2 years, that there's been this ongoing issue about whether people who earn commissions, bonuses, and a number of other different types of elements of pay are losing out when they take annual leave, and for that annual leave, receiving basic pay only. In relation to the Lock case, it obviously included results-based commission. We did suffer a loss for taking a period of leave, not necessarily in the holiday pay period, but maybe the month after. I've got lots and lots of people asking me about how to do calculations and how to calculate what do we, how things are implemented, and reference periods, etc. But the court in this case, so it just happened in October actually, the Court of Appeal expressly opted out of addressing the question of the appropriate reference period to calculate commission elements. And it's also understood that British Gas intends to apply for leave to appeal to the Supreme Court. So I'm not sure that this holiday pay thing is going to be resolved anytime soon. I know it's absolutely riveting, must be keeping you all up at night. It certainly is me. But again, keep watching this space. Wow, take a deep breath. Right. So what we're looking at now is the Apprenticeship Levy. Okay, so have you heard about this? Hopefully you have. It's coming into effect from the 6th of April 2017. It's an additional tax, I suppose, which will be 0.5% of the total gross pay bill for companies, excluding benefits in kind. But there is an annual allowance of £15,000. So in reality, there's only going to be this levy payable on pay bills over 3 million. And in relation to that 3 million figure, the idea is that the government's aiming to get 3 million new apprenticeships in by 2020. Apprenticeship seems to be the word of the moment. The HMRC is saying that the levy will be paid by less than 2% of employers. But it's basically just supposed to get the market going again in relation to apprenticeships. So that's all I want to say about that, really. I don't think it's it's going to affect many people. It will affect quite a few, obviously, but not too many. 11% of businesses who have been polled in a recent poll say that they felt the reforms would would increase the number of apprentices that they've recruited, and 5% said that they thought the levy would have a positive impact on their training budget, apparently. So who knows what's going to go on there. Oh, crikey. I think my house is burning down. Just bear with me. Is everybody still there? I'm not sure what's happening here, but obviously I'm presenting live. Anything can happen. Feel like Davina McCall. Right, okay. So can everybody still hear me? Yes, brilliant, thank you. Right, great. So, also if you work in the public sector then, so I'm still on the Apprenticeship Levy, in addition to the levy, public sector bodies in England with 250 or more employees will be subject to an apprenticeship target. So they're going to need apprenticeship staff to comprise of at least 2.3% of the total workforce each year, and that's interesting, isn't it? I think there'll be quite a lot of recruitment going on there. The levy is expected to come in 2017. Okay. Now, Modern Slavery Act then. I'm sorry this is a bit of everything, but we did say we'd give it an update. So, looking at the Modern Slavery Act 2015, we've got Section 54 of the Act. It includes a provision for large businesses, and I've said there with a minimum total turnover of 36 million per year, to publicly state each year the actions that they've taken to ensure that their businesses and their supply chains are slavery-free. Okay, it came into force on October 2015. It applies to financial years ending on or after the 31st of March. There's publication of the statement required as soon as reasonably practicable at the end of the financial year. The guidance has been sort of within 6 months. And in relation to the content of the statement, if it affects you, you can get good precedents from your advisors in relation to the statement content. But basically, the guidance recommends that the statement's written in plain English, easily accessible to everyone, succinct but covers all the main points, and in English, but if required, to be able to be provided in other languages that are relevant to that particular company's supply chain, which is, I suppose, quite straightforward and makes sense. It must include either a statement of the steps that the organisation has taken during the financial year to ensure that slavery and human trafficking is not taking place in its supply chain or its business, or that the organisation hasn't taken any steps. So, I could talk a bit more about that, but the content-wise, take some advice if it's applicable to you. You have to make the statement published. Basically, it's probably putting it on a website or a link on the website. And there you go. If you require any further information about that, then, as I say, take some specifics. Now, tax. This is another thing that people have been asking me about. There's been quite a lot of discussion about this one. In relation to the tax regime at present, this is the simplification of taxation of termination payments. So I'm not a tax expert. I'm not qualified to advise on tax, of course. But we all know that if we're making a termination payment and it's genuine compensation, there's a £30,000 exemption. It's the first £30,000 can be made tax-free. For a long time now, people have been speaking about whether a payment in lieu of notice is taxable or not, whether it's a contractual payment in lieu of notice, whether there's an absence of a pile-on clause in a contract. And basically, the consultation that's been recently entered into confirms that from April 2018, the government's going to remove the distinction between contractual and non-contractual payments in lieu of notice. In other words, so that every payment in lieu of notice will be treated as earnings subject to income tax, employer national insurance contributions and employee national insurance contributions. But it will retain the exemption from income tax for payments relating to genuine termination up to the current threshold of 30,000. Okay, national insurance contributions from the employer side are payable above the 30,000. So these are changes. If you do deal regularly with termination payments, settlement agreements normally, then be aware of these, keep your eye on what's happening and take some proper advice. In relation to your settlement agreements, have them reviewed, make sure they're up to date. I've come across 3 in the last week that have been provided to individuals, some of which are simply not fit for purpose. They've been regurgitated, rehashed. Some had the old employees' name in. I know it's easy to do, but particularly if there are changes around the tax treatment of these, do get them updated by your advisors. I've got somebody saying the sound's cutting out there, but I don't think I can do anything more about that. Sorry about that. I'll try harder. Whistleblowing then. So I've got a few cases here now. Do you remember about whistleblowing and the public interest? So just recently, the Employment Appeals Tribunal has given its view on the meaning of the words in the public interest that were inserted into the whistleblowing legislation by the Enterprise and Regulatory Reform Act 2013, and this is for disclosures made on or after 25th of June 2013. Okay, so what used to happen with whistleblowing is that we used to be, at one point, have employees saying they were whistleblowing because their contract had been breached in some way. But really it was something particular to them. My contract's been breached, I've made that allegation, I'm a whistleblower, and that was changed. Well, we tried to get away from that by saying, no, definitely for whistleblowing it needs to be in the public interest, okay? Well, this recent case of Chesterton Global has said that it isn't necessary to show that the disclosure was of interest to the public as a whole. So it's the case that it's looking at whether what is the public interest, basically. He says it's inevitable that only a section of the public will ever be directly affected by any given disclosure. And in this case, there was a small group of people who were affected by the disclosure, and it was about 100 senior managers. And they said that would be enough to satisfy the public interest test in a whistleblowing case. And also that the worker need only demonstrate that they reasonably believed the disclosure was in the public interest. So we're sort of coming away from well, it's just been clarifying the current position really, but it's bringing claims back into the fore on that. Now, let's have a look. Oh, I'm going to skip over that slide. That was something we did about tweeting and race discrimination, which I don't have time to do now. Another case that might be of interest to you then is this G4S Secure Solutions case. Okay, this is of interest to quite a few of my clients, so I've put it on the slides for today. It's about dress code, and it was about the banning of a Muslim headscarf and whether that was justified. And in this case, I don't think we've actually had the overall outcome yet, but certainly last time I looked, the Advocate General's opinion was that a Belgian company's dress code, which banned employees from wearing any visible religious, political or philosophical symbols in the workplace, and it was used to prevent a Muslim employee from wearing an Islamic headscarf. His view was that this did not amount to direct discrimination because the ban affected all employees equally. So whatever religion they were, it was a uniform, neutral dress code, basically. It said, it's gone on to say, it was not based on stereotypes or prejudice away against one or more particular religions. And even if it did amount to direct discrimination, the view was that it might be regarded as a genuine occupational requirement. So we're still looking at that now. There's been quite a few other cases going backwards and forwards on dress at the moment, which might be of interest to you. So if you do Google that case, or if it's of interest to you afterwards, there'll be a number of other ones that come up, which will point you in the right direction. There's been quite a few that go the other way, but we'll see. Right, so another one here. I've got indirect religious discrimination. This has been a case recently in May, Pendleton. Now, this case was of interest to quite a few people in the face-to-face session, and the Employment Appeals Tribunal in this case has held that a teacher had suffered indirect religion or belief discrimination. Okay, so basically what happened in this case, The teacher was a lady, and her husband was the head teacher of another local school. So she was a teacher and he was the head teacher of another local school. He was convicted of downloading indecent images of children. And she was dismissed for standing by her husband. Okay. Now, she said that she had made a decision because of the marriage vows and specifically a commitment in the presence of God, for better or worse, to obviously stand by her husband. And as a result of that, she was dismissed by her school, who said, well, we can't have you here, it's not the right thing to do. And the Employment Appeals Tribunal had said that was indirect religious discrimination. So that's also an interesting case that you might have seen or you might not have seen. But it highlights the difficulties in assessing what's fair, what's not fair, trying to balance the rights of employers and employees. Okay, so in relation to job applicants, this might be good news for some of you. This case, Kratzner, sorry, no V on the end. The European Court of Justice has held in this case that where an individual applies for a job but only in order to seek compensation for discrimination and not genuinely to obtain employment, that they're not covered by the Equal Treatment Framework Directive. In other words, that they can't claim discrimination. Okay, so for those of you who receive speculative applications from people who maybe just then want to approach you after the event, say, I didn't get the job, I think it's because, then this might be of interest to you. Obviously, it's a bit more complicated than that, but if you're interested in job applicants and the discrimination legislation around that case is definitely one to have a look at. Now, looking at work placements, there's been a recent, in June, I think, this year, Blackwood and Birmingham Solihull Mental Health NHS Foundation Trust. In this case, the Court of Appeal has held that the university student can bring a discrimination claim directly against the provider of a work placement when they've suffered discrimination during the period of the placement. Again, I am getting short of time now, so I won't go into the what's and wherefores of that one, but it is an interesting case if you are a provider of work placements, and definitely you should certainly have a look at your policies and update your equal ops, etc. in relation to that. And coming to the end of it now, you'd be pleased to know, ramping forward, so there's another G4S case here about reasonable adjustments, which is of interest to people. So I'm told the Employment Appeals Tribunal has held that an employment tribunal was entitled to find that the employer was required to keep paying an employee, a disabled employee, who was actually taken and carrying out a more junior role at his previous level of pay. So in other words, that the question is whether an employer was required to continue employing in a junior role at the previous rate of pay, and whether that was a reasonable adjustment under the discrimination legislation. And in this case, it held that it might well be. Now, I wouldn't start, reaching for the knives just yet, based on that one, because I don't think by any stretch, having read the case, it means that somebody is protected and can carry out any job that they want and can demand levels of pay as a reasonable adjustment going forward. I certainly don't think it means that. But in that case, it probably was fact specific, but I would take advice as to reasonable adjustments and have a look at that if anybody does mention pay and pay protection to you. Okay? Now, finally then, just looking at this ACAS Code, I get asked a lot of questions about this, and there's been a couple of cases recently this year about it. So the ACAS Code doesn't apply to every kind of dismissal, does it? I think this is a common misconception. So in Holmes, the Employment Appeals Tribunal said that the ACAS Code really only applies to dismissal as an element of culpable conduct. In other words, whether in the form of misconduct or poor performance, where there's an element of punishment required or correction. So if, for example, there's a dismissal process that goes forward and it's as a result of illness, then the ACAS Code probably wouldn't apply. In the other case on that slide, Phoenix House, the Employment Appeals Tribunal considered the ACAS Code again, whether it applied to a dismissal for some other substantial reason, and decided it did not. So I think really we're looking at the ACAS Code for misconduct and capability issues mainly. So remember, it doesn't apply to every area. Okay, I put questions there, but I know that we're running extremely short of time. I just would mention another case that I found of interest the other day, which we were discussing during the face-to-face, which is the case of Unite, the union, and NAILAD, N-A-I-L-A-R-D. It interested me because I act for a couple of employers who are unionised, and the Employment Appeals Tribunal has held that 2 workplace union officials employed by a private sector employer but working full-time on a union business were agents of the union for the purposes of the Equality Act. In other words, that the union was potentially liable for workplace harassment carried out by them of another union employee. So that was a really interesting case. So it's Unite the Union and NAILAD, N-A-I-L-A-R-D. That came out in September, just after, I think it was the day that we did the face-to-face, and that interested me. So if you've got a unionised workforce and you want to have a look at liabilities for unions, or if you you are a union, have a look at that. It's an interesting one. Okay, so I think we've just galloped through, cut out quite a bit of the stuff from the face-to-face, but that's just sort of the main employment law update for now. Any questions I'm quite happy to take, or if you want to email me directly after, it might be better, because I think we'll probably be finishing off and all going and eating our sandwiches now. Are you there? Karen, are you there?
Oh, yep, I'm here. Sorry, I was waiting to see if any questions came through.
Okay,
and
we're getting
just
some
come through
questions
now.
Okay.
Yes, we've got just a few minutes to answer what you can, and then the rest of them we'll put out an email after we've done the webinar with a link to this, and also any key points that need making out of the back of these questions.
No, hang on. I've got one. Oh, here we are. For the end of any sight of national minimum wage for April 2017. Do you know what? I'll have a look at that. Just bear with me. What is the national minimum wage for 2017? I might have that with me, or I might be able to email you afterwards. Got quite a lot of documentation here actually today. See if I can get this in. National minimum wage 2017. Go on, keep going. Just bear with me. I might drop you an email. That's the living wage. We did something about the living wage the other week, didn't we? The national minimum wage.
I think, Marie, if there's
any links that we can...
Yeah, I was going to say, if there's maybe a link or two that we can send.
1st of April 2016. No, yeah. I haven't got it off the top of my head, but I'll just send you a link afterwards. If you want to just drop me an email, I'll send you a link to all the statutory rates. All right, that's come out again.
Brexit-related regulations for current EU workers.
Yeah, no, I'll come back on all of them. Oh, yeah, there is one question here that we were looking at recently. There has been a recent case for shared parental leave that amounted to sex discrimination due to the difference in enhanced pay for the lady and the gentleman. He did bring a claim, and he was awarded, I can't remember the name of the case off the top of my head, but he was awarded the pay he should have received in the end, had he received pay of, equal to that the lady was entitled to. My advice on this, well, as far as I understand it, the outcome of that case for the employees of that business was that the employer simply just reduced their entitlements to the minimum. So they stopped enhancing for everybody.
Network Rail, I think this was one of the big rail providers, and they've said although it's a win for the chap who took them to court, it's actually a detrimental effect because they've changed their policy now
And that is always the case.
Everybody.
I mean, if you look back to pensions, there was a pension dispute many years ago when I was doing a dissertation at university, so that's how long ago it was. And the outcome of that was that nobody actually won in the long run. Everybody just got a reduced amount. So, yeah, I'm not really impressed with that one. But no, so I don't really have any advice. Okay, right, lovely.
Okay.
So I think that's it, Karen, is it?
Thank you very much, Marie. I think we're starting to lose people now, so we'll let you all crack on with what remains of your lunch. As I say, we'll drop an email out after this with a link to the webinar and also a couple of links to the questions that have been asked. Thank you all very much for your time. Keep an eye on the Shorebird TV website for upcoming webinars throughout November and December. We're currently planning in a few more, so hopefully you'll see that populating over the next week or two. And we look forward to speaking to you again soon. Thank you.
Yeah, lovely. Thanks, everyone. Bye-bye.
Thank you.